So how does something become an exhibit at trial? An exhibit is usually a document, a photograph, maybe it's an object. And the simplest way for something to become an exhibit at trial is when both parties agree. One side says, hey, I want this to be an exhibit. The other side says, hey, I want this to be an exhibit also. They agree, and that's probably going to be an exhibit at trial. Now, a lot of times people do not agree. One side's got something they want as an exhibit, and the other side does not want that to come in as evidence. So what happens then? Well, there's going to be a dispute, and ultimately the judge is going to determine whether or not it comes in before trial even starts, so the jury's not going to hear about it. And one of the very common objections has to do with foundations. So we're not talking about the bottom of a house. We're talking about the facts that support that the picture, photograph, document is what it purports to be. So, for example, let's say someone's got a great picture of a bloody knife on the ground. Okay, you would think maybe that would be relevant to the case, but there's a lot of questions about it. For example, who took the photo? You probably want the person that took the photo to be able to come into court and testify, yes, I took this photo. You also need to know where the photo was taken. You need to know when the photo was taken. And all of this is very important to authenticate the photograph to make sure that it is actually relevant to this case and wasn't just some random bloody knife on the ground that somebody picked up in the former Soviet Union in 1962. So just because you've got something that looks like it might be great evidence does not mean it's automatically going to come in at time of trial.